finally putting Roe to rest. That's the focus of tonight's Angle. Today's oral arguments in the biggest abortion case since Casey versus Planned Parenthood, they were certainly fascinating to listen to, but they simply confirmed what conservative legal scholars have been arguing for nearly 50 years, that the reasoning in Roe was pure legal fiction. The court never should have waded into the abortion wars. Now, perhaps the most revealing and disturbing part of the argument came during a discussion of stare decisis, the idea that court precedent, here Roe versus Wade, should generally be respected to preserve a measured, predictable development of legal principles. But left-wing justices and their supporters in the press, come on, they've largely abandoned the notion that any textual provision of the U.S. Constitution prohibits states from preventing the killing of the unborn. At this point, their main argument is that Roe has been on the books for a long time, and it's too late to do anything about it. Well, that's absurd. The notion that the American people are stuck with a wicked decision just for the sake of tradition goes against everything the country stands for. By that reasoning, Plessy versus Ferguson, which allowed segregation for over 50 years, would never have been overturned by Brown versus Board of Education. The Mississippi Solicitor General Scott Stewart, who was arguing in favor of his state's 15-week abortion ban, also argued against bowing to precedent when much has changed since Roe, including new imaging technology.
I think it's an advancement in knowledge and concern about such things as fetal pain, what we know the child is doing and looks like and is fully human from a very early...
In 40% of dead people who, if you touch their feet, the foot will recoil. There are spontaneous acts by dead brain people. So I don't think that a response to by a fetus necessarily proves that there's a sensation of pain or that there's consciousness.
I mean, how twisted, how callous, and how uninformed. Now, by Justice Sotomayor's logic, I don't know, expectant mothers shouldn't get too excited when their baby kicks in the womb. After all, the baby could be dead and merely twitching. Now, a couple of the liberal justices contended that overturning Roe would destroy the court's legitimacy. Now, Justice Breyer said that overruling unnecessarily and under pressure would just lead to the condemnation of the court, loss of confidence in the judiciary, the ability of the court to exercise the judicial power and to function just as a Supreme Court dedicated to the rule of law. Justice Sonia Sotomayor basically said the same thing. But she added that, will this institution survive the stench that this creates in the public perception, that the Constitution is not just, being interpreted as political acts by the court? Well, Justice Sotomayor is right to worry about a noxious stench, but it's the one the court created in 1973 when it robbed the states of their right to determine this issue for themselves. Now, in the words of the late, great Antonin Scalia,
regardless of whether you think prohibiting abortion is good or whether you think prohibiting abortion is bad, the Constitution does not say anything about it. It leaves it up to democratic choice. Some states prohibited it, some states didn't. What Roe versus Wade said was that no state can prohibit it. That is simply not in the Constitution. It was one of those many things, most things in the world, left to democratic choice.
Boy, I wish he was there today. Now, the late Judge Bork was even more blunt than Scalia, calling Roe an act of judicial imperialism. In other words, inventing out of whole cloth constitutional rights that the framers just never intended. Now, the legal defenders of Roe contend that a woman's right to privacy and bodily autonomy somehow trumps the right to life of the unborn child. Exposing the illogical core of this argument, Justice Thomas asked whether other actions beyond abortion are similarly protected. He said, there was a case out of South Carolina involving a woman who had been convicted of criminal child neglect because she ingested cocaine during pregnancy. And the woman arguing for the Center for Reproductive Rights said that those issues aren't posed in this case. Well, she didn't answer the question because doing so would collapse the house of cards that Roe was built upon. Now, the court in Roe, and like the American left, has always used this viability argument to justify depriving infants of their own constitutional rights to life. In other words, they're not really persons under the Constitution unless they're viable outside the womb. Justice Samuel Alito smashed this entire line of reasoning, and he basically said, does a woman not have the same interest that she had before the viability of the fetus, being free of this pregnancy, that she no longer wants to continue? And again, a lawyer could not argue the point. She just said, well, viability is a principled line. You get my point here. Justice Alito was right to raise this. The viability standard, it's not what the court is tasked with doing. The fetus has its own individual rights. Well, he's precisely right. But Democrats are just the members of the party of death. So basic logic and essential truths, when life begins, doesn't matter to them. Abortion is their holy grail. And Joe Biden, who likes calling himself a Catholic school kid, he's too unprincipled to take the stand that his own faith requires. Well, that led Justice Brett Kavanaugh, at the end of the oral arguments, to raise the issue that the liberal justices conveniently avoided. He said there's also an interest in fetal life. That's at stake as well. And again, Biden's Solicitor General gave a non-answer to Kavanaugh because there is no answer. The fact is, neither the framers who wrote the original Constitution and the Bill of Rights, nor the drafters of the 14th Amendment ever intended to create a constitutional right to abortion. Indeed, they would have found such a concept to be barbarous and evil. The left claims to care about democracy. So let's let the people decide the important questions presented by abortion. And if a court with a majority of 6 Republican appointees fails to put Roe to rest, then it should expect a conservative-led movement to shrink the court's power. Oh, and would also mean adios to the Federalist Society.